very warm welcome. This is the second module of week 5 of the course Entrepreneurship and IP Strategy, titled Copyright and Related Rights. In this module, we will see what are related rights. In the earlier module, we have seen what is copyright, and then we have seen the subject matter of copyright. We know now that literary or dramatic work, musical work, artistic work, photograph, cinematographic film, record, these are the subject matter of copyright. In that connection, we have also seen the details such as what includes in literary work, what is dramatic work, and all such kind of details. We also know that artistic work includes paintings, sculpture, drawings, engraving, etc. Engraving is etching, lithographs, woodcut, prints, and all that kind of activity or artistic creation. We have also appreciated that computer program is literary work and can be protected by copyright. Kindly note one more thing, that is government work is copyrighted work. Now, what kind of government work is a copyright work? It includes the work which is made or published by or under the direction or control of a government or any department of a government. So, it will include legislature in India, also the publications by court or any judiciary authority, that will be copyrighted. It will also include that the material which is published by any government, what we can say the department, or due to any government, whatever the outcome of any meeting or deliberation is there, that will also copyright of a government, that will be a government work. Now, further we also noted that copyright expires after a certain period of time. So, there is a certain lifespan, or there is a what we can say specific period of time is there for which period that right exists, and after that, that particular creation will come into the public domain and anybody then can use that creation. For example, we know that suppose we take an example of a creation by say Rabindranath Tagore ji. So, whatever the creation is there, the time span we know, that is a 60 years. Now, how that 60 years? After the death of the author, and that 60 years will be calculated from the next year. So, if we calculate in that particular way, what will happen? That author's life plus that 60 years, that will what we can say the period of a copyright is, and after that, that will come into the public domain, and therefore, in that way obviously if you do the calculation in that way, you can understand what exactly is a copyrighted material and what is now already what we can say the copyright material is. So, if you do the calculation, obviously such creations which are what we can say in 1800 or before that, already all these things are in the public domain. Okay. So, we have also seen that who is the author, means who is the owner of that copyright, and we have seen the different subject matter, and according to different subject matter obviously author is changing. So, we will go little bit more detail about that particular aspect, that term of copyright. When we are talking about that term of copyright in anonymous and what you can say pseudonymous work, it will be like a next year after the first publication. So, you can understand here we are not aware about the author. In normal case we are saying that a life of author plus 60 years. Now, here in anonymous work or pseudonymous work, what the thing will happen, that okay, this is published in this year say 2020, then from the next year that 60 years will be calculated. So, that way the calculation is done. In case of photograph, what is a life? Already it is, we have discussed that it is a 60 years, but it is next following the year in which the photograph is published. So, from the publication date it will be calculated. Same thing with a cinematographic film, when it is produced and when it is released, from that time the next year will be considered, and from that next year we will calculate that 60 years. Okay. Same thing with a sound recording, we have seen that particular thing. Now, What about a government work? What is the life or that expiry date for that? So again, the government work, again it is a literary work, it will come under that, and therefore that lifetime of that work will be 60 years. So in that way, if you see that copyright, mostly that 60 years is a timeline. Obviously I will put some point here that in India it is a 60 years. If jurisdiction changes, that lifetime changes. So for example, in USA it is a 70 years. So it depends on in which territory that particular what we can say the work is, you are considering the what we can say copyright law and all that details. So this will be very useful when you enter into online mode. At that time, depending on the area or a territory where that copyright will be as access, that land law will determine, that particular territorial law will determine that particular lifespan. So now we are restricting here to India. So in India it is a 60 years. Okay. Now, so now we will move further and we will see what exactly the related rights are. So these related rights are two important related rights: broadcasting right and a performance right. Now what do you understand by broadcasting right? We generally hear the word that okay, broadcasting right is there. Or that particular thing is broadcasted. Radio is broadcasting, means on radio some program is broadcasted, or on television some program is broadcasted. So we are aware about that broadcasting word as such. But what do you understand by broadcasting right? Now you can see the names here on the here, that Eros or ESPN. Probably you have seen these words many times, especially when you are seeing a cricket match, you say that okay, ESPN and all. So that kind of words you are very well aware about. Now, ESPN is an American sports channel and is jointly owned by Eros and Walt Disney Company. Now, ESPN is owned and controlled by Eros. The digital media management arm of Eros is taking care of that particular division. Now, what is the meaning of broadcasting? That we have to understand first. It is nothing but a communication to the public. Broadcasting is nothing but a communication to a public. Okay. How that communication is made? So this can be by wireless diffusion or it by using the wire. So either wire, with wire or without wire. So that is a wireless diffusion is there. Now generally we know that broadcast include any one or more of the forms of a signs, sounds or a visual images. When you see the cricket match or live cricket match that telecast is there, or parliament sessions, whenever you see that sound, that visual images, obviously any form of signs, that kind of scenario is there. Now broadcasting can be commercially, it can be a commercial activity, it can be a public, what we can say broadcasting, or it can be a community broadcasting, any kind of broadcasting may be. Now because of broadcasting, exactly whatever is going on live in say the cricket match, if it is going on in Australia, you can watch sitting here in your home. So that is a benefit of broadcast, and that is started, means if we see the history of broadcasting, it is I guess in 1937 that broadcasting that technology or that what we can say use of broadcasting is started. Now many times we see on the screen that there is written that live something like that. So we understand that okay, this is a live session going on, or sometimes it is a recorded. So any kind of that what we can say the outcome is there, but that whatever is a broadcasted, which is communicated to public, obviously that will come under the broadcast, and there are rights involved in that broadcasting. Now this broadcasting, whatever the activity is done, this is done by the agencies, and we call these agencies as a broadcasting agencies. Now Eros or ESPN, Sony, these are the broadcasting agencies, and obviously for that broadcasting they are getting the rights lawfully. So if cricket match is going on the ground, say Wankhede Stadium, obviously one of that broadcasting what we can say the organization or agency, they have received rights lawfully from the organizers, and then only they are broadcasting that particular match or any activity or any program which is going on. So obviously that agency which is broadcasting take the rights from the organizers. Obviously organizer will not give that rights freely, some consideration will be there, and broadcasting agencies will give that consideration to the organizers. So it will include the what we can say, if you take a simple example of ICC, International Cricket Council, example of a fortune or a wealth involved is like this, that ICC receives approximately $1.98 billion for the period from 2015 to 2023. So, the contract between that broadcasting agencies and ICC, the time period is 2015 to 2023. Now, during that whatever the time period, it is that contract is of $1.98 billion. So, you can imagine the involvement of a fortune in the copyright, that is a here the related right, that is a broadcasting right, and that much amount is given to the organizer by these broadcasting agencies. And therefore, if you remember in the introduction video, we have shown the money shower kind of one clip actually. So, you can imagine that if this kind of amount is involved in a copyright, that is a $1.98 billion in that time span is pretty well 2015 to 2023, but you can imagine the IP right and the returns on that particular what we can say the IP. So, therefore, we have to understand or appreciate the what we can say the IP rights, and same thing will happen, means with the patent also you will see, or industrial design also, or a trademark also. We will see that few valuation examples of a trademark we have already seen in our earlier module. So, you can see the one trademark, if it sold, that particular amount goes into the $1 million or $1 billion also. So, we have already seen that particular example when we have dealt with a trademark law. Now, considering this related right, which chapter in the Indian law or Indian Copyright Act is dedicated to this what we can say related rights. So, in Indian Copyright Act, chapter 8, it deals with the rights of a broadcasting and that performing rights. So, these related rights are dealt in a chapter 8. Every broadcasting organization receives a right called broadcast reproduction right. Now, what is the term broadcasting right is? It is the term in the sense the life of that broadcasting right. We have seen that 60 years is for a copyright, we have seen that example. Now, what is the right for broadcast, what is the time period frame for a broadcasting right? So, once any agency receives that broadcasting right, that right is for 25 years. So, you can understand that suppose Sony receives the contract from the say ICC, for that contract will be, means once they receive that particular match what we can say that happens suppose in 2020, then from next year, that is 2021, we have to calculate 25 years. Till that 25 years, Sony will own all the rights of broadcasting of that particular cricket match. Same thing with a, say on the radio, some program is what we can say they have recorded some program. Obviously, once they record that program for broadcasting, they will get the right for next 25 years. Okay. So, that way the broadcasting rights are for 25 years, copyright 60 years. Okay. So, it is from the beginning of a calendar next calendar year, that from that January we have to calculate the time frame. Now, what rights broadcasting organization is getting? First, it can stop anybody who is broadcasting the content without permission, obviously, because they have paid for that and they will not allow anybody to broadcast that particular thing, because obviously you know that when they are doing a broadcasting, so many advertisements are that they will show you advertisement, and that is a revenue generation for them, and in return already they have paid for that particular organizers for particular that program. Okay. Second, if somebody make a broadcast available on a payment basis to the public, that is an infringement. Means if somebody have recorded that and for a small group, but they are taking a returns, a commercial activity is done. Although it may be a small group or a local activity, if somebody do that kind of a broadcasting, obviously that is an infringement, and obviously broadcasting whosoever is owning that broadcasting right, they can take the action. Third thing is that if anybody make the sound recording or visual recording of a broadcast, then it is a crime and it will attract a legal action. So, if some cricket match is going on and if you do the complete recording of that cricket match, and then you start displaying that particular thing, and obviously you are making it commercial activity. If that kind of activity is done, it is you are not a legal, what we can say, owner, or you have not received the rights for that recording until you have recorded, until you are putting it into the what we can say social media, or you are using it for some commercial activity. That is not at all allowed, because you have not received rights of broadcasting. If someone makes any reproduction of such a sound recording or visual recording without license, so that match is there. You have, suppose, buy that particular, say, CD or something like that, any form, if it is available, you have bought that particular thing, not necessarily cricket match, it may be some other program, some what we can say, the live concert is there, and you have recorded that particular thing, and then you start selling the copies of that, that is again the infringement, and the owner can, what we can say, they can take action against that particular activity. Then obviously the copies, if you sell it in the form of a disc or some any other form, or license, you have created your own business model based on that without getting the proper rights, obviously you are attracting a legal action. So you can understand that what exactly the broadcasting right is there, and what are the rights of broadcasters, means when any broadcasting agency receives that rights, what rights they are receiving. And we have seen in the copyright, reproduce and all that 4 categories are there, that economic rights are there. So same applies here in the broadcasting rights. Now we will move further to the performance right. Now performance, if you see that you can remember immediately the performance of Amitabh Bachchan, or performance of Kapil, means the comedy show which is Kapil Sharma is what we can say is hosting, and obviously the live concerts or the performance of Lata Didi. Now here what the thing is happening is that this performance, whatever is made, it is a visual or acoustic presentation, it is made by a one or more performance. So if we try to understand legally what that performance is, that is the visual or acoustic presentation made live by one or more performance, and that performer, he gets that performer's right, means as he is exhibiting that particular activity, or he is what we can say presenting that visual or acoustic presentation, he or she is getting that performing right. Now the question comes, who is a performer? Means if we want to see the definition, whether only this what we can say cine stars are the performer, or who else is there. So obviously they are, so all actors, actress, whatever, singer, then musician, then dancer, acrobats, juggler, conjurer, snake charmer, or a person delivering a lecture, or any other person who makes a performers. So this list can go increasing. So you can understand whosoever is doing a performance, that person or that individual is a performer, and for that particular acoustic and visual presentation, he or she is getting the performance right. Okay. So for example, if somebody is giving a speech, then obviously the person who is giving a speech, he is performing in one angle, and therefore obviously that is his performance right. Okay. So what is the term of that performance right? We have seen the term for copyright, it is 60 years. For broadcasting right, it is 25 years. Now for a performance right, this time frame is a 50 years, 50. Okay. So we have to remember 3 timelines when we are dealing with the copyright and Indian: 60, 25 and 50. Okay. Now which are these rights? Means when we are saying performer is getting the rights, what rights obviously he is getting? So he is getting the rights like he can take action against an infringer. Now you know what that infringer is. If somebody is doing means what we can say, the infringement here is like somebody makes a sound recording or a visual recording of the performance, or reproduces that sound recording or a visual recording of the performance, or broadcast or rebroadcast the performance, that is a sound recording or a visual recording, or communicates the performance to the public. Okay. So, if any of these activities are done without permission, that will attract a legal action. Now, we have seen in the copyright there are few exceptions, that section 52 we remember. So, similarly here few exceptions are there, that there are certain acts that will be considered as a that will be considered as okay, it is a fair use and that will not attract any legal action. So, which are these exceptions? So, if any sound recording or visual recording is done for a private use, then that we can say that okay, this is not a infringement, or such recording for a purposes of a bona fide teaching or a research. Okay. So, many of the art school will require that kind of videos for some analysis or some other what we can say research, then that will not at all attract any legal action, that is a fair use. Then sharing that clips or excerpts of performance of a broadcast in a reporting of a current events or for a bona fide review, then that will not will be considered as a what we can say infringement. So, for example, if Prime Minister Modi ji, if he gives a speech, and obviously that giving a speech means he is a performing. So, if he is a performing, he will get the performance right. So, whether he can if any news agency on the TV channel, any TV channel, if that particular clip, that particular speech is broadcasted, whether that is affecting the performance right? No, that will not affect, because that particular small part of that speech is just given as a what we can say, it is like a sharing of the facts, that is a news sharing of the facts is there, and in that case it will not attract any legal action against any of the news channel or any TV what we can say channel, and that is allowed. So, this kind of act is allowed, that will not attract any legal action. Okay. So, that way this performing right is for 25 years, and you can understand what is included in the performing right. Now, we will watch one video here. So, what that video is there, what that video is about actually. So, you can see that in this video there is a discussion about a copyright bill. So, Javed Ji Akhtar, he is presenting it in the parliament. You just go through the what we can say, what his opinion and what we can say the as a actual what we can say a part of a film industry, as he is a part of film industry, he know what exactly the issues are, and just watch that what is his presentation in the parliament.
No, he has agreed. आप बोलिए. He has agreed. सहमत गए आप बोलिए. आप बोलिए. Everybody wants to listen to you. Okay. आपका speech सुनने चाहते हैं. बोलिए. Yes. It is made and speech. बोलिए. 20 minutes तक लेगी.
One, that I must immediately declare that whatever I am going to say will have something to do with this bill under consideration, which has something to do with music industry, and I work for music industry. My relationship with music is what a farmer's relationship with agriculture or a lawyer's connect with judiciary. So I hope it will not be considered any kind of conflict of interest. एक, अब आइए वापस आते हैं जिस मुसीबत में मैं हूँ और हमारे हजारों फनकार हैं. सर, बड़े ज़माने से ये तकलीफें थीं, लेकिन शायद हिंदुस्तान के कलाकार समझते थे कि बोलेंगे तो सुनने वाला कौन है. लेकिन अब वक्त बदल रहा है, लोग बदल रहे हैं, हालात बदल रहे हैं. उम्मीद करता हूँ कानून भी बदलेगा और हिंदुस्तान के कलाकार.
Okay, so you can watch this video later. Here, if you see that if I want to relate this copyright here also, you can just see Javed Akhtar is giving the speech or his what we can say some what we can say his experiences related or his the issues which film industry is facing. So, the content which is he is presenting, that will be obviously a copyrighted material as a literary work. Then the activity means the way he by which he is presenting that, it is his performance right. Then you can see that that is a broadcasted, right, as a, it is a parliamentary session, it is a broadcasted. So, that included a broadcasting right, it is a public broadcasting. So, that is a broadcasting right is also involved. So, that way I mean you can see that okay, this copyright. So, these three aspects you can easily identify in that clip also. Then sound recording is there, then all that what we can say related copyright related activities are there. Okay. So, now you can appreciate now that performing rights are related to a performance. It may be a TV serial, it may be a cinematographic film or any audio visual medium. It may be a what we can say delivering a session by a teacher, that is also performing. Any speaker who is giving the speech, that is also that is also performance, what we can say performance, and that will give him a or her performance right. Okay. So, we have also seen that broadcasting rights are there, and broadcasting what we can say the agencies are getting that rights from the broadcasting agencies by giving some consideration, and obviously that is a strict what we can say contract, and through that contract that activities are controlled. Okay. So, up to this I guess you are very clear about that related rights. Now, we will move further, and now we will see that something about a copyright societies. Now, what these copyright societies are, that we will not go much details, but just a glimpses of that, because when we say that particular audio visual clips are there or any sound recording is there, if anybody want that copyrighted material, to whom they should contact, and how they can get a legal rights over that. Okay. So, they can contact these copyright societies. Now, three copyright societies: Society for Copyright Regulations of Indian Producers of Films and Televisions, in short it is SCRIPT script for cinematographic films; Indian Performing Rights Society Limited, that is IPRS, it is for musical works; and Phonographic Performance Limited, that is a PPL, that is for a phonographic performance. Now, these are the three societies. How to contact them and how you can get the right, it is a very simple process. In upcoming module, we will see the registration of a copyright, although we have already seen that it is not required. But if anybody want to do that registration, what is the procedure for that particular copyright registration, that we are going to see. So, at that time we will give you the fees and the procedure for applying for this. If you want to get some copyrighted material for your personal use or for commercial use, you can apply to these copyright societies and you can get that rights. What the fees are, all these things we will discuss in the upcoming module. Okay. Now, why these societies are there? That these societies are the easy, what we can say, a very easy way to get the access to the copyrighted material. And obviously, there are certain norms, government has put some norms, and if that norms are followed, then only the registration of these copyright societies are allowed. And these are obviously proper societies under the government with some that stipulated government guidelines, and that registration number and all that legal, what we can say, legal compliances whatever are there, that all these things are followed there. Okay. So, the that procedure we will see in the upcoming module. Now, as we have seen already that copyright societies, moving further we will see little bit about conventions. So, we have seen one convention, if you remember, Berne Convention. So, do you remember how many contracting parties are there with the reference to Berne Convention? 178, yeah. Okay. So, we will just give you the name of that treaties which are related to the copyright. We will not go into the details of that particular conventions. The important thing for you now as a starting, what we can say, if you are starting or trying to understand this IP, is you just know, okay, under copyright what particular, what we can say, the subject matter is covered under copyright, what is the lifespan for that particular thing, and how you can register that particular copyrighted material. And if somebody by ignorance, if you do, or if somebody do the infringement of your copyright, what possible actions you can take, and if you are doing by ignorance, what possible actions come against you. That much information if we get through this initial understanding, if we know, then probably we can if that base is clear, then you can go further and go in the details of that. So, I will just give you the examples of few conventions. So, there is a Brussels convention, then Rome convention is there, then WIPO performance and phonograms treaty. I guess you remember the long form of WIPO. WIPO is like a World Intellectual Property Organization, that is a what we can say central body, or it is a the international body which take care of all IP related activities at an international level. Now, adding to that particular thing, that WIPO copyright treaty is also there, that WIPO copyright treaty and WPPT, that is a WIPO performance and phonograms treaty. This together it is also called as a WIPO internet treaties, and that is what we can say, it is a very apt in this current scenario. That most of the activities are now happening on a online or with a digital media. So, that when it is on a digital, what we can say digital activities are there, this kind of treaties are making important role, and probably some probably with the current scenario there may be some amendments or some additions, that deliberations will be there, and that there is a possibility. Okay. So, as the point came related to digital media, we will just discuss little bit about that, because even e-commerce, we are dealing with the e-commerce, that e-commerce obviously it will involve the copyright. So, in the digital media, when we are dealing with the digital media, if we see the website now, the picture you are seeing is a IIT Kharagpur website actually. So, any website if you take, any web page you take, it is a copyrighted material. So, nobody is allowed to copy any material on that website, and this website is like a, what we can say, it is like a feel, it gives certain feel, and then it gives a, so the presentation style is a peculiar to that particular website, and obviously that will have the copyright. So, nobody is allowed to copy that particular material or a content or photographs or the way arrangement, it is not allowed as such to be copied, because it will attract a legal action. Okay. So, here obviously, we have just seen that WCT is there, WIPO copyright treaty is also involved in that particular thing. So, I guess with this we are coming to the end of this module, and by this time with these 2 sessions related to copyright, probably we are able to make a foundation that what is the subject matter of copyright, then what are the related rights, and the time lifespan of a copyright. In patent we have seen that it is a 20 years, or in the trademark we have seen it is a indefinite, it is a renewal, you can renew it and it can have a indefinite, what we can say, life. But in copyright if you see 60 years, 25 years and 50 years. So, 60 years literary work or sub copyright matter, then the broadcasting rights are 25 years and a 50 years performance right. So, I guess with this we will come to the end of this session. See you in the next session. In this in the next session we will see how the registration of a copyright can be done. Thank you.